Hello, everybody, and welcome to History/Law Bite number 192, dated February the 22nd, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Fletcher versus Peck, 10 U.S. 87, 1810. Fletcher versus Peck was a very important martial court decision handed down in the early part of the 19th century that dealt with the issue of just how far the Contracts Clause, located in Article 1, Section 10, Clause 1, would reach. In this case, after the Revolutionary War, the state of Georgia acquired a ginormous tract of westward land, a total of nearly 55,000 square miles of territory from the Yazoo Native Americans. All right. And essentially, that land, vast majority of it anyway, would end up becoming two new states, Alabama and Mississippi. All right. The Georgia state legislature would divide the land up into tracts, and via the Yazoo Land Act of 1795, it would sell this land at dirt cheap prices. I mean, dirt cheap prices, prices that would blow your mind, all right, even for that era, okay? And all seemed fine, well, and good, except not long thereafter, the people found out that this law was enacted largely due to individuals bribing members of the state legislature, all right? And as such, virtually all of them were kicked out of office in the next election cycle, all right? When the new legislature assumed office, they immediately repealed this law and canceled all rights and land acquisitions and claims under it, all right? So all of that was theoretically wiped out when the legislature repealed the Yazoo Land Act of 1795. One of those individuals who made a purchase under that act was a man by the name of John Peck, all right? Mr. Peck would sell part of his land acquired under the act to Mr. Robert Fletcher, all right? A few years after that was done, all right, Mr. Fletcher filed suit against Mr. Peck, arguing that because the legislature had repealed the law and thus canceled all the rights and claims attained under it, that Mr. Peck had no right to sell him the land from the get-go. All right? Strange, I know, right? If it sounds strange, you're on the right track because there was clear collusion in this case. Both men would obviously prevail, you know, as long as the Supreme Court ruled that the Native Americans did not hold the original title to the land, all right? So, in his suit, Mr. Peck filed in federal court, he asserted, like I said, that, Mr. Fletcher asserted that Mr. Peck did not have the right to sell him the land because the legislature had repealed the law, thus canceling all claims and acquisitions made under it, all right? And Mr. Peck argued the opposite. So the Supreme Court more or less had to face the singular issue of whether or not the contract between Fletcher and Peck was invalidated legally because the Georgia state legislature repealed the law under which their contract, had been procured, essentially. All right. So via Chief Justice John Marshall, okay, the Supreme Court unanimously ruled that the Georgia state legislature had acted unlawfully here in repealing the 1795 law, as the states in general, had no right to cancel out and invalidate an existing contract, even if its methods were secured through illegal bribery. All right? So the Contracts Clause in Article 1, Section 10, Clause 1 of the Constitution was given mighty force here because the court reasoned that contracts are so sacred and so important, so essential, all right, in the process of business and freedom in general, that states had no right to abrogate them, even if the contracts were secured illegally, which was certainly the case here, as bribery had been the essential promulgator for this law getting enacted. All right, so all the contracts made under the law essentially were party to illegal bribery. All right, so didn't matter though. All right, even if the contracts, had been formed by suspicious or dubious or unlawful methods such as bribery, the motive behind the 1795 law, state legislatures had no power to thus void them and cancel out anything that was of relevance and had already taken place under the contract. So the strength and power of contracts was certainly enforced through the decision in Fletcher versus Peck. Of course, through the years, however, the decision's force is not as powerful as it was when first handed down. There have been exceptions made to the contract clause. But with respect to this case, once more, the decision of the court was that the power of state legislatures did not extend to the reach of being able to invalidate existing contracts, even if they were secured through unlawful methods. In this case, bribery. All right? So, any questions, controversies, leave them down below, and I'll be happy to answer them. All right? Hope you learned a thing or two from this video. I appreciate you listening. If you have not subscribed to my YouTube channel, please do so now. It would be graciously appreciated. I appreciate all your support. All right? Take care. Stay safe out there, and I'll talk to you at the next bite. Peace.